Citizens United 2 years later, Money and Politics in 2012. I'm Caroline Fredrickson, the president of the American Constitution Society, and I think it's a testament to the great interest and concern that people have about this decision, that we have such a wonderful turnout early on a Monday morning. And so for those of you in this room who are not familiar with the American Constitution Society, we are a national network of lawyers and law students, judges and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues through the development and promotion of high-impact ideas. We are delighted to co-host this event today with the Center for American Progress, with whom we've been working closely in recent years to bring attention to the importance of the courts and to highlight the real-world impact of judicial decisions. Today's discussion takes place at an opportune moment. This week, we mark the second anniversary of the Supreme Court's decision in Citizens United versus the FEC, which struck down significant portions of the bipartisan campaign finance reform law that Congress had enacted and turned aside long-standing precedent upholding the government's ability to regulate corporate influence on our elections. Ever since that decision was issued, we've been asking questions such as, what will be the ruling's practical effects? What does the overruling of long-standing precedent on campaign finance suggest about the Roberts Court and its respect, or lack thereof, for precedent? And what's next? What can we do to address the consequences of that decision? What better time to start answering these questions than the beginning of another campaign season, or I guess we're actually launched well into that campaign season. But it is the perfect moment to examine the impact of Citizens United. As we follow the constant news reports of the latest super PAC ads in the Republican primaries, one has to wonder what limits remain on corporate spending in elections, and how can we best protect our democracy? Former Justice John Paul Stevens, who wrote the oft-quoted dissent in that case, appeared last week, I'm sure many of you saw it, on the Colbert Report. Even at age 91, Justice Stevens exhibits as sharp a mind as ever. Justice Stevens told Colbert, as with natural persons, as with corporate persons, some have different rights than others do. The same rights don't apply to everyone in every possible situation. Such a simple and clear explanation for such a complex issue. Lucky for us today, we have an extraordinarily knowledgeable panel to help us navigate these waters further. Our moderator will introduce the panelists, but I have the honor of introducing him. As you all know, I am sure, E.J. Dionne writes about politics in a twice-weekly column and on the post-partisan blog for the Washington Post. He is also senior fellow in governance studies at the Brookings Institution, a government professor at Georgetown University, and a frequent commentator on politics for National Public Radio, ABC's This Week, and NBC's Meet the Press. Please join me in welcoming E.J. Dionne and our distinguished panelists.
First of all, I apologize that we started a little late. That was my fault. To quote a famous political figure, I misunderestimated the time it would take me to get here. And unfortunately, my name is not Stephen Colbert, but we can be grateful that he has been calling some very useful attention to this issue. I'm very honored to be here. I'm very grateful for the work that CAP does on so many issues. And I am so grateful that the American Constitution Society exists and has done some very, very important work. It's possible to think of worse Supreme Court decisions than Citizens United. But after you get past Dred Scott, it takes a significant amount of research, I think. The Santa Clara decision, which is interpreted as declaring corporations a person, might go in there. Lochner might go in there. But I think that this decision really falls into that category of the sort of very bad decisions that got made, or at least as I see got made in the Gilded Age. For those who think that Supreme Court decisions can have only a limited effect, I ask you only to look at this presidential campaign. It is the charitable interpretation is that the court was naive in understanding the impact that this decision might have. That's the charitable interpretation. There are less charitable interpretations, which we might also talk about here. But we have an extraordinary panel here today, and I'm going to introduce them in the order in which they will speak. Melanie Sloan is the executive director, Citizens for Responsibility and Ethics in Washington. Her organization has gotten a lot of play in the Republican debates recently, which is not necessarily a place she expected to get all this publicity, but she has. She serves as Crew's executive director and is a nationally recognized expert on congressional ethics. Before she worked at Crew, she was an assistant United States attorney in the District of Columbia. She tried cases before dozens of judges. She was minority counsel for the House Judiciary Committee, working on criminal justice issues for the ranking member, John Conyers. She also served as counsel to the Crime Subcommittee of the House Judiciary Committee, chaired by then Representative Chuck Schumer. She drafted parts of the 1994 crime bill, the Violence Against Women's Act. And I always know somebody's way smarter than I do when they have at least one degree from the University of Chicago. She has two, a BA and a JD from the University of Chicago. So Melanie will lead us off. She'll be followed by Monica Yoon of the Brennan Center, Constitutional Fellow at the NYU School of Law. She is the inaugural Brennan Center Constitutional Fellow at the NYU School of Law, where she focuses on election law and First Amendment. She previously was in private practice, was a law clerk to Judge John T. Noonan, actually I should confess, one of my favorite conservative judges, extraordinary man, in the U.S. Court of Appeals in the Ninth Circuit. She received her JD from Yale Law School, her MPhil from Oxford University, and a BA from Princeton University. She's the editor of Money, Politics, and the Constitution Beyond Citizens United. I like that subtitle a great deal. Lastly, Jeff Clements, co-founder and general counsel, Free Speech for People. It sounds like that new singing group, but we won't go there. Yeah, Foster the People will sing at a fundraiser for you. Yeah, President Obama did a pretty good job the other day. Jeff is the co-founder and general counsel of Free Speech for People, the founder of the Clements Law Office. He was Assistant Attorney General and Chief of Public Protection and Advocacy in the Massachusetts Attorney General's Office. He led more than 100 attorneys and staff in law enforcement and litigation. He also served as Assistant Attorney General of Massachusetts from 1996 to 2000. Where he worked on litigation against the tobacco industry and wrote a wide range of led a wide range of other investigations and litigation. He is a graduate of magna cum laude graduate of Cornell Law School, and he is the author of, very relevant for today, Corporations Are Not People, and it's a subject that he will instruct us on. Today, I also see my old friend Garrett Epps in the audience, and I can't resist beginning this with an observation that has become one of my favorites from Garrett, which is that today's originalists say, I knew the founders were friends of mine, I know what they think. That's his definition of originalism, which actually could enlighten us in the course of this discussion. I give you first Melanie Sloan.
Thank you all for coming today. I think the major point I'm here to give you, and since you all are here, so many of you probably have been following the issues of the super PACs quite closely, and in some ways I may just be telling you things you know, but I think that one of the key things to focus on is that one of the things the super PACs seem to be doing in this election cycle is that they are allowing candidates who otherwise would not still be in the race to be in the race. The fact is, Newt Gingrich would no longer be with us in this presidential race if it hadn't been for Sheldon Adelson's $5 million contribution, which allowed him to flood the airways with some pretty negative ads about Romney at the very end of the South Carolina week upcoming to its primary. That money also, Rick Perry had a significant amount of money that also allowed him to stay in the race much longer than he would have. I mean, I think for most people, when you can't remember the names of the agencies you want to cut, that would have been it in prior years, and yet he was able to stay in much longer than that. And so I think that's the thing to take away. Would we still have Newt Gingrich in this race were it not for the influx of money? And now the question is, will he continue to have that influx of money, and will it make him competitive in Florida? Florida is already, Romney has already spent, I brought some numbers with me here, his Restore Our Future PAC has already spent $5 million in Florida, and his campaign has spent another $3.3 million in Florida, and Gingrich doesn't really have anything much spent in Florida yet. The next person who spent money in Florida is actually Santorum's super PAC, Red, White, and Blue, which has spent only $224,000. So without money, can Gingrich really keep up the momentum that he has? The numbers that the other thing that's important about the super PACs is they have dwarfed campaign spending. The presidential candidates themselves, in Iowa alone, it is believed that the super PACs outspent the candidates themselves by 2 to 1. And as we're already seeing, candidates are saying they don't have control over the message of the super PACs. Now, there's certainly questions about whether that's true or not. As I'm sure you know, there are rules against coordination, so super PACs can't coordinate with the campaign committees. But that said, the super PACs are run by close friends and associates of all the candidates, and they often announce their strategies publicly, and they put things on their website, so there's not a lot that the candidate committees have to guess about. Romney and Gingrich have both decried the super PAC ads against them, while saying that they can't do anything about the super PAC ads that have been running against their opponents. So, you know, it's kind of hard to buy their crocodile tears over those ads. I think an interesting development that we're seeing, that's the presidential, so I think you really just have to watch the money, how much money is being spent. We will see the first numbers for, on January 31st will be the first numbers that we'll get for the latest spending. Some super PACs that have been newly created this year won't be filing. We won't be seeing any numbers from them for a little bit longer, till I think it's February 20th. I think is that right? So it's really a big question about what all those numbers will be. The other thing that I think you should keep a lookout for, even when we finally see these the candidate reports and the super PAC reports filed with the FEC, what you got to look for is that sometimes there will be no name that you know associated with that donation. The contributions may well be by C4 organizations, and these C4 organizations, which are social welfare organizations that are allegedly engaged in charitable activities and can't engage in electoral activities as their primary purpose, many people who don't want their names out there are donating to the C4s. And you will see, by the way, C4s running ads also throughout the presidential and the congressional races. But you will also see that there will have been donors to C4s, and then the C4s will donate to the super PACs. And in this way, even though super PACs have to disclose their donors, many of the donors to the super PACs will, in fact, be cloaked behind the C4. One other thing I think you should note is that super PACs are not limited, as much as it seems like they are right now, to the presidential race. We're now seeing congressional super PACs as well for specific candidates. In 2010, we saw American Crossroads have a super PAC, but now we're seeing candidate-specific super PACs. For example, Orrin Hatch has one. One thing to keep an eye on is what's going on in Massachusetts, where Scott Brown and Elizabeth Warren are both claiming that they are they're trying to come up with some agreement whereby neither side will allow super PAC ads. And you know, one question is, can they really do that? Because the super PACs, as we know, are allegedly not coordinating with the campaigns. But Elizabeth Warren has just sent over to Scott Brown a proposal whereby if somebody runs a super PAC ad, say somebody runs a super PAC ad in favor against Scott Brown, that the Elizabeth Warren campaign committee would have to contribute half the ad's value, and I don't know if that's how much it costs to air it or what it costs to make it. That wasn't so clear. But donate that money to a charity. On the other hand, and Scott Brown, it looks like they're going to come to some kind of agreement. But that said, the League of, I think it's Conservation Voters, which is already running ads in Massachusetts, and somebody who's running ads in favor of Scott Brown, have both said that they are not willing to yet endorse this strategy. So they may well, it could be that Brown and Warren come up with this agreement, and yet super PAC ads are run anyway. And because in a lot of ways, people don't have some control over the super PACs, and we are going to see more and more of these ads. So I'll stop there.
And before Monica starts, I forgot to say, would everybody please turn off your cell phones? It's not just that they can interrupt the discussions. I'm told they can do weird things to our sound system, and we might get a super PAC ad broadcast that would interrupt us. So if you could shut off your cell phones, I always forget, so that's why I'm reminding you. Monica, please.
Very happy to be here, and thank you so much to ACS and CAP and to all of you for being here today. So over the past 2 years, I've had to read Citizens United, I think, an unreasonable number of times. And I think what strikes me every time I have to crack open the decision again is not only the badness of the decision, as EJ points out, but also the smugness of the decision. And I think that in some ways the badness of the decision is related to the smugness of the decision. And the smugness, I think, really centers on 2 points: the way in which the Supreme Court treats what I'll call the money is speech syllogism, and secondly, what they say about corruption. And let's start quickly with the money is speech syllogism. The Supreme Court says, okay, well, money is speech, everyone should speak, corporations are everybody, corporations should speak, corporations should spend money in elections, and they smile and everyone goes home. But despite the irritatingness of that particular syllogism, of which I know that Jeff will have quite a lot to say, it's still not my least favorite part of Citizens United. I think my least favorite part of Citizens United is the sentence where Justice Kennedy says, well, independent expenditures cannot give rise to corruption or the appearance of corruption. And he just states this as a statement of fact, no evidentiary record, no sightings to experts, no nothing. Just Justice Kennedy, in his infinite wisdom, just knows this to be, absolute truth. And I think what's been interesting over the past 2 years is sort of watching this crumble. You see this crumbling, you already saw it crumbling in the Supreme Court's Caperton decision, which Justice Kennedy had written prior to Citizens United, where he said, well, and the way in which he tries to justify this in Citizens United. Caperton had to do with independent spending in judicial elections, and Justice Kennedy basically in Citizens United tries to deal with that holding by saying, well, we know that independent expenditures can bias and corrupt judges, but judges are supposed to be unbiased and uncorrupt, whereas somehow it's okay for, legislators and our other elected representatives to be, biased and corrupted by money. He doesn't say it that baldly, but that's kind of the implication of his decision. But, a little bit of a crack in the smug facade there. I think another thing is the super PAC phenomenon, which Melanie's just been talking about, which is, what does it mean to be independent? Is it independent when a candidate shows up at a fundraiser for his own super PAC, and this is somehow considered to be an independent organization? Is it independent with the former campaign manager and the former financial director of a national campaign move directly from the campaign to the super PAC? Is that still considered independent? And the way in which Stephen Colbert is making super PACs into a national joke about our campaign finance system is, I think, starting to crack the facade. Thirdly, there was the Blumen versus FEC decision. This was the decision about foreign spending in elections, which the Supreme Court summarily affirmed, I guess, last month. And, in there, again, the logic starts to break down. Well, if independent expenditures are so uncorrupting, then why can't foreigners make them as well as Americans? Why can't foreign corporations? What exactly is the logic of that decision? The Supreme Court did not have to provide an opinion in that decision, but still, it really starts to, if independent expenditures are so pure, then what exactly is the fear of foreigners and foreign corporations and foreign influence over elections? And finally, kind of my favorite development of recent months, which might be sort of short-lived, is the Montana Supreme Court, bless them, have basically upheld a state law analog to the corporate spending ban that was struck down in Citizens United, basically saying, look, Supreme Court, you don't know corruption. We know corruption. It's interesting to note that the Montana Supreme Court is elected. And they said, look, we had a long history of copper barons and mining interests basically trying to buy our elections. We passed this law 100 years ago. We love this law. And we want you to tell us why somehow in that last 100 years, we as a state legislature lost the power to say, this is corrupting, this is not what we want in our politics. And what exactly is the reasoning that, why exactly it is that we can't legislate against that kind of corruption. So, we'll see how long that lasts. I mean, it's kind of waving a red flag to the Supreme Court, and, I think there's a 90% chance that it's going to be struck down, but it's still kind of cheering to see that resistance. And speaking of resistance, I just wanted to end with this note. Citizens United did a lot, and it was a terribly bad decision, but it's not alone in blame. There are various elected, there are other people who could be doing something about the super PAC situation. Congress could be legislating. We know Congress failed to pass the Disclose Act, but there's certainly a range of other things that they could be reviving. They could be reviving real disclosure law, real shareholder protection law. They could be reviving both the congressional and they could be reviving the presidential public financing system. They could be moving along on the congressional public financing system. All of these things are not foreclosed by Citizens United and are just a failure of political will that I think we need to be on them about. I think that we need to be on the Obama administration. 5 out of the 6 commissioners of the FEC are now acting under expired terms. I know that a group of reform organizations, including CREW, just circulated a petition to the White House to say, look, President Obama, the FEC is a public laughingstock. It doesn't need to be this way. Let's make this an issue. Let's actually say there are things that can be done. These coordination rules can be overhauled. There are reforms that could make a difference, not just in the long run, but in the short term. And I think also we as progressives need to do a little bit of soul searching ourselves. I think that, it's great to focus on the long term. I tend to focus on the long term in terms of constitutional change. I know that Jeff is working toward the same long-term goal, but there are also things that we can be doing on the short term. And we need to be thinking, are we willing to apply real restrictions, not just on candidates we hate, but on candidates we like? Are we willing to look into our own organizations and say, are we willing to disclose if we're going to ask others to disclose? All of these things. So I think it's a time for the progressive movement to really say, look, are we serious about this or are we not?
Monica, thank you so much. I just want to say, we Catholics like to talk about purgatory, and so every time you read Citizens United again, you reduce the number of days you have to spend in purgatory. And I just
4 years in Catholic girls' school. I really appreciate that.
and I hope we can talk some more about 2 things you mentioned, which is within the framework of Citizens United, what can be done, even as many of us hope someday this whole thing is knocked down. And secondly, what could the FEC be doing that it's not doing? Because I think there's a case to be made that the super PACs did not have to take the form they did or even exist if the FEC had done some of its work. Jeff, thank you for being here.
Thank you. I'm very glad to be here, and thank you all for coming. Thanks to ACS and CAP. I look forward to the discussion about working within the framework of Citizens United, but my main message today is how we overturn the framework of Citizens United and why a constitutional amendment, the People's Rights Amendment, or other appropriate amendment language is both necessary and a compelling opportunity in many instances. And the reason I say that is because in many ways Citizens United, I call it in my book, since it's football playoff season, an end zone dance for corporate rights, and so a celebration of a longer term transformation of our Bill of Rights and our Constitution over the last 3 decades into the Lochner of our time, the corporate trump card over the public interest. And that's true whether you're conservative, progressive, or in between. So Citizens United is really a culmination of a corporate speech doctrine, a corporate rights doctrine that began in the late 70s. The first case, really one that was revived by Citizens United after being somewhat banished by 2 other cases that upheld corporate regulations and campaign finance, was the Bellotti case in 1978 in Massachusetts, which struck down the law there that we had that restricted corporate spending and citizen referenda. Lewis Powell, considered a moderate, something I hope to change with debate and conversation. I think he was a radical in many ways, wrote the decision. The same Lewis Powell who wrote a memo to the Chamber of Commerce before he went on the court, advocating for a long-term, well-organized, well-funded corporate campaign to transform what he called the social, legal, and political culture in America. He was nominated the same day as Justice Rehnquist, not the most popular justice in ACS, perhaps, although I won't presume to say that, but well, widely regarded as a conservative, of course, and made no bones about it. Justice Rehnquist dissented in not only in Bellotti, but in the other cases that Lewis Powell wrote, 5-4 decisions saying corporations have a speech right to strike down laws, something that was unheard of in American jurisprudence before the 1970s. And that corporate speech doctrine has struck down environmental laws, financial regulation laws, public health laws, disclosure laws, and more across the country, state laws, federal laws, and Citizens United, in many ways, is the logical conclusion. If you accept that corporations have a speech right, a utility corporation has a right to defy state policy of conservation, to promote energy consumption, because it's in the interest of the shareholders. If that's a First Amendment right, well, if that is corporate speech, and corporations are just like people when it comes to speech, then political speech is even more important. So the logic of Citizens United follows from that acceptance that there is such a thing as corporate speech rather than human speech. So, you know, my book isn't the most nuanced title, Corporations Are Not People, but it is a more nuanced argument, I hope, than that. And it really starts with some going back to sort of first principles of not only what is our Constitution and Bill of Rights, it's for people, but what is a corporation? You know, a state public policy tool that we the people create and ought to be able to write the rules for. So the constitutional amendment campaign would overturn Citizens United, but I'd like to put it in the historical context in 2 ways. One, Citizens United in many ways is the sort of wake-up call that I think progressives need to examine. I'd agree with that, but all Americans need to. Have we really done our job as citizens to keep an eye on these powerful, artificially created global corporate entities that we give advantages to, like limited liability and perpetual life and so on? Are we doing our job at making sure, as Justice Rehnquist said in his dissents against this doctrine, that economic power is not leveraged into undue political power? That was his concern. That was why he thought, of course, state laws, federal laws can write the rules for what corporate conduct and political activity ought to be. So the constitutional amendment is not only the necessary result to overturn the Supreme Court when they've gone off the rails, as we've done at least 7 times before, but it's also the opportunity to carry this conversation around the country to say, you know, not only is Citizens United wrong, but do we need to re-examine our constitutional framework for the 21st century? And in that way, I think it's much like the Progressive era and other times in American history where there's been a moment when we've seen not only a sort of Gilded Age, but a wave of reform to transform a stultified democracy that's overcome by corporate economic might, like in the Gilded Age. And then constitutional amendments are part of that conversation and bring along a wave of really what's renewal of democracy. So if you go back to the Progressive era, they not only got the antitrust laws, conservation laws, labor laws, everything else, but they had an ongoing battle with the Lochner Supreme Court that didn't really end until the New Deal. They did 4 amendments to the Constitution in 10 years. One of them was dumb. It was the prohibition amendment. But the other three were really important that we take for granted now. Women vote. We elect senators directly. We can do a progressive income tax. So those were conversations and debates with the Supreme Court under Article 5, essentially, where the American people used the tool that we were given by our framers to have the last word about what is our Constitution, what is our Bill of Rights. I see Doug Kendall here. The Constitutional Accountability Center has a fantastic issue brief out right now about the Pollock decision, which struck down the progressive income tax, said that Congress does not have the authority to enact a progressive income tax. Again, the progressive era was struggling with how do we renew American democracy and make it work for a new century. And the amendment campaign to overturn Pollock, if you think it's hard to overturn Citizens United, imagine trying an amendment campaign to get an income tax. I mean, you needed an American consensus, 3/4 of the states, 2/3 of Congress to say, yes, we want to tax ourselves because we need to make America move forward. Well, that's the kind of opportunity we have now, and that's what's happening now, I think. It's an American conversation that is happening across the country, across parties. Our polling with Peter Hart shows that's the case. 79% of Americans, Republican, Independent, and Democrat, support a constitutional amendment to reverse Citizens United. I think it's what happened in Montana when the Supreme Court of Montana stood up. We did a amicus brief there on behalf of some Montana businesses and the American Sustainable Business Council. It was a 5-2 decision, and if you thought the majority, which essentially defied Citizens United, did not like Citizens United, you should read the dissents, which said we have to follow Citizens United, but then went on for about 80 pages to say how much they hated it and how wrong it was, and ended with the irony is that unlike people, corporations can't go to hell. And so it was a little bit of Montana straight talk back to the Supreme Court.
Purgatory to hell in one conversation.
So this is happening. There's been resolutions calling for an amendment from LA to New York to Portland, Maine, to towns in Montana, Colorado, all over the country. There's state resolutions pending. We've got a dozen amendment bills now pending in the Senate and Congress, and that can seem like a problem. So many amendment bills, which one works? It's a good problem. That's what the debate is going to be. We're going to have a debate about what's the right language, how are we going to get this right, and it's going to be a reform moment that I think will surprise a lot of us. So my main point is this goes beyond campaign finance, it goes beyond the presidential race. It really is about the power of people in this country and whether we are going to renew ourselves yet again to be a government of, for, and by the people rather than by the corporations.
Thank you so much. Just so everybody knows, I'm going to sort of have a conversation. We're going to have a conversation up here for about 20 minutes, and then we will open it up to the audience. I know there are lots of incredibly knowledgeable people out there, and we want you to join us. I'd like to start a bit of a colloquy between Monica and Jeff, and then I'd like Melanie to help us on, we're focused on super PACs now. What else are we going to see later this year? But Jeff, I am sympathetic in general to the idea that progressives have not been imaginative enough in thinking about amendments. I mean, we had the Civil War amendments, which were an important constitutional moment. Then we had the Progressive Era amendments. I worry that in the current circumstance, given the radical inequality in the size of the states, the provision of the Constitution to amend it is much harder to use now. It gives extraordinary veto power to a very small proportion of the country. And as long as Citizens United exists, one can imagine enormous lobbying efforts on the very issue, say, of overturning Citizens United that could make it very difficult to alter the Constitution, which is why I also want to go to Monica to say, it strikes me that especially in light of this decision that seems to contradict Citizens United saying, well, foreign corporations can't do this. Well, once you say that, then you raise a whole series of questions. Well, how will we know if foreign corporations are in there? What kind of regulations do we need to prevent foreign money from coming into the system? And slowly but surely, you would have to reconstruct a system of regulating campaigns to prevent at least one thing that the court seems to think might be corrupting of our system. So I'd love the two of you to talk about, if you will, the constitutional strategy versus the legislative strategy. Maybe, well, since I put the challenge to you on the amendment, why don't you go first?
So the question really is, how, put less politely, get real. Constitutional amendments don't happen anymore. It's too hard. There's no way that all that corporate money is going to oppose it. We're not going to be able to get a constitutional amendment done. Now that's not what you said, but I'm happy to put it to the
Unfair.
the most extreme.
Fairer than I've seen in many of these debates lately.
So here's what I say to that. First, I think we need to remember actually that it wasn't just the Civil War. It wasn't just the Progressive Era. That we don't sometimes I didn't realize, frankly, until I started down this road. In the 20th century, we amended the Constitution in every single decade except the 80s and the 40s. The most recent one was 1992. Now, footnote, that was first proposed by James Madison, so one might argue that took 200 years to get done. But in the 60s, late 60s, early 70s, another, I would argue, moment of renewal of American democracy. My book starts with Earth Day. 20 million people came out in the street. President Nixon in the White House, and we got the Clean Water Act, the Clean Air Act, the EPA, Endangered Species Act, and on and on and on. Democracy was working. We got a constitutional amendment to lower the voting age to 18. We got a constitutional amendment to eliminate the poll tax. So these moments happen when it becomes essentially an American consensus that we got to get it done. Now, if I'm wrong about that this is that moment, then this won't happen. But if we test this proposition, I think it's going to happen. And the fact that there's small states actually cuts in our favor. The Article 5 requires 2/3 of Congress to send the amendment out to the states for ratification by 3/4 of the states. There's also the convention route, but we haven't had a convention since Philadelphia, so we're not talking about that right now. And things like Montana, states like Montana have the most to fear from Citizens United. As Attorney General Bullock says there in the case, in the litigation, the average state legislator in Montana, the winning campaign spent $17,000. Okay, so this is a citizen legislature that has the most to lose if corporations are unregulated in political spending. I think we have a compelling argument. I think the amendment actually can take off, and in some ways, the more money that's spent against it, the more it illustrates the point. I don't think Americans are missing what is happening with the spending, and I don't think they're liking it. And then just to segue to Monica, because I think the other thing we will see is a recognition that we can't keep foreign money, if you call it that, out of our politics if we don't overturn Citizens United. As Monica said, it was just almost delusional for Justice Kennedy to say, oh, well, don't worry, disclosure will happen. Oh, don't worry, we won't have foreign money in elections. News Corporation is an active spender. They funneled at least $2 million into the chamber to spend on November 2010 elections. The number 2 shareholder with 2 billion shares of News Corporation is the Kingdom Holding Company of Saudi Arabia. So these corporations aren't American corporations anymore. They're global, multinational, if you will. UBS, a big lobbying spender, is one of the major investors, maybe the largest, is the Republic of Singapore. So the structure of corporations, you can't separate out, oh, that's American money, don't worry. That's foreign money. It can't be done.
And so let me go to that, which is 2 things. The whole notion that corporations are the creation of the state. What prevents Congress from redefining corporations that would actually begin to solve some of this problem, A? And what prevents Congress from saying, aha, the Supreme Court has said foreign money can't come into campaigns, so any corporation that has any foreign ownership is automatically excluded from this right. Why can't that happen?
I'm not sure whether the Supreme Court would be willing to uphold the latter of what you're talking about. I mean, there is such a thing as unconstitutional conditions doctrine, and I think if the Supreme Court believes that this is a pretext for preventing corporations from spending in elections full stop, then I have no, I believe that the current majority would strike it down. That being said,
How would they rationalize this, one with the other?
You know, it's interesting how, you know, this rationalization dance that, you know, has been going on for quite a while that, you know, Justice Kennedy did in Citizens United when trying to distinguish Caperton, and now the, you know, the summary affirmance in the Blumen case, like, honestly, no one's going to call them on the carpet to say, you know, explain yourself. You just don't get to do that to Supreme Court justices, more's a pity.
But so what can we do legislatively?
I mean, legislatively,
And also the FEC, what might the FEC do within the framework of Citizens United? Because it doesn't seem to me we have to be quite as far down this road as we are.
Exactly. Well, what Citizens United does is it reifies the distinction between contributions and expenditures, which everyone who has taken like First Amendment law remembers you had to learn in Buckley versus Vallejo. It made no sense then. It makes even less sense now. But the definition, you know, the difference between an independent expenditure and a contribution is defined by what counts as coordination. And the FEC has power to define what counts as coordination. And there's quite a lot that can be done along those lines. There's quite a lot that can be done on disclosure legislatively and administratively. I mean, I think Jeff referred to Justice Kennedy's kind of delusional worldview in Citizens United. There's this whole section where he goes off on, well, of course we have a world of perfect transparency now where shareholders and voters are able to hold corporations accountable for all kinds of things, and not seeming to realize that, you know, corporate spending does not need to be disclosed to shareholders or even to corporate boards. But a lot of that, I think, could be dealt with through, you know, through legislation, both at the federal level and at the state level.
Can I chime in on the issue of the FEC?
Yeah,
So the FEC is really a massive problem, and frankly, this is one that we can now lay at President Obama's feet. You know, we sit there and talk about everybody else, about how the Supreme Court came out with Citizens United and Congress didn't pass the Disclose Act, but the fact is President Obama campaigned on campaign finance reform issues, and the Federal Election Commission is a disaster, as John McCain often calls it, the little agency that can't. It absolutely refuses to enforce the law. It makes it clear over and over and over. And as Monica said, 5 of the 6 commissioners are sitting there despite expired terms. And Mr. Obama has not even nominated somebody for the FEC since his failed nomination of John Sullivan in 2009. And that is simply inexcusable. And we need to ratchet up the pressure on him severely about this. You campaigned on it. Americans across the board care about this issue, and you could do something now. We don't have to get to, of course, the constitutional amendment strategy is terrific. All of these things are important. But there is something that our Democratic president could do right now, and that is nominate people for the FEC. Now, obviously, that we're in a difficult situation with confirmations, but he isn't even willing to have the fight. He's not even naming anybody so we can talk about this. I think it would be a great argument to take to the American people. Here, the FEC isn't doing anything. We have these people who would come in and enforce the law, and let the Congress argue against that. Let's have that debate in the public. I think Americans are ready. We have seen some of the most embarrassing decisions out of the FEC on issues like coordination. For example, last year, or 2 years ago, there was this case with failed Senate candidate Christine O'Donnell, and the Tea Party Express was supporting her. And the Tea Party Express, somebody from the Tea Party Express said that they talked to Christine O'Donnell's campaign every day. They talked every day. And the FEC still split in a 3-3 decision. No, that's not coordination. There's no proof they spoke every day. The fact that he said they spoke every day isn't even enough to prove that they spoke every day. I don't know what else you could actually be looking for coordination.
I'm not actually speaking to Melanie here, just in case you.
I get upset about it because it's those kind of, and that is not the only bad decision at the FEC. We see bad decisions if they can bother to make a decision at all. In some cases, sit there for years and years and years. Crew files a lot of FEC complaints, and many of them are not decided for several years. And so when they do make decisions, they split 3-3 on them frequently. And we have Republican commissioners like Don McGahn, who used to be Tom DeLay's campaign finance lawyer, who has said that he, first of all, doesn't believe in enforcing campaign finance laws, and second, that he believes his job on the FEC is to help Republican candidates. Okay, I don't know exactly how that's supposed to be, and President Obama is leaving him there. And at some point, President Obama said, well, he didn't want to have a fight with Mitch McConnell. I'm sorry, he didn't want to have a fight with Mitch McConnell? What exactly is Mitch McConnell working with President Obama on now so well? I mean, hasn't Mitch McConnell said that his whole goal is to keep President Obama from winning another term in office? So it doesn't really make sense that you don't want to have that fight. And that's why, as Monica said again, we have this petition now, and I hope all of you will sign it. It is a petition to say President Obama has said that if any petition gets 25, these are White House petitions, says if you can get 25,000 signatures, they will issue a response. So we, along with Common Cause, Democracy 21, Public Campaign, Public Citizen, Campaign Legal Center, have been working to push out this petition to say, you, President Obama, tell us what you're going to, there are 5 of the 6 commissioners have expired terms. What are you going to do about it? When are you going to appoint new commissioners? And hopefully that will push the White House to respond to that.
Thank you for that. And if he actually talks, as he's expected to, about campaign finance reform in his State of the Union, it seems to me it opens this argument even more. What I'd like to ask you is, what I'm fascinated about is, in the absence of a constitutional amendment, which even if my fears about it are not justified, would still take a while. It does seem to me that Citizens United may leave more room than we realize to get certain things done that at least prevent the system from going entirely off the rails. What could, if the FEC were an actually functioning body, what might it do now about super PACs and some of these other abuses that would likely stand the test of court challenges even within the context of Citizens United?
Number one thing there is disclosure. Citizens United itself upheld the concept of disclosure, as did another case after that, which I'll forget the name of, but Monica will know right off the top of her head.
Doe versus Reed?
Yes. So the concept of disclosure has been upheld twice. The FEC has refused to issue regulations requiring more disclosure in super PAC ads. So, for example, they could require disclosure that anybody who contributes $1,000 to an ad, their name has to be disclosed on the ad. Instead, it's just "Restore Our Future" is the tagline on the ad. But it could be that they require all the names of the people who spent the money, gave Restore Our Future the money for the ad, and that would really help. And so I think we could see a much greater disclosure regime, and yet the FEC, the commissioners have said, frankly, they're not interested in that.
Can I speak to that as well? So, you know, the other related piece of disclosure is government contractors. Corporations have massive amounts of government money flowing through government contracts. And about 8 months ago, President Obama, it was leaked, perhaps a trial balloon, had on his desk an executive order that would have required disclosure of corporations that have government contracts of their political spending. And that makes eminent sense. If you have been spending in order to help elect the chair of the Appropriations Committee and then have a several $100 million government contract, that's something that people ought to know. We don't know it. 8 months ago, when that leaked, the Chamber of Commerce, which the president, Tom Donahue, says is a $200 million lobbying machine that when we bite you on the butt, you bleed, started biting and said literally that they would go to war over that. And here we are 8 months later. It's still sitting on the president's desk, metaphorically speaking. I don't know that. But somewhere in there, it's there to be signed. And so I want to emphasize, I think the constitutional amendment is really important. It's clearly not the only thing to do. And I think we can take a lesson from conservatives and the right who figured out a long time ago constitutional amendment campaigns are how we continue a conversation about values in this country when the Supreme Court does something that they believe is wrong. In this case, we believe it's wrong. I think the right believes it's wrong as well, I'll say. But it's a conversation about values, which then helps drive, those value conversations help drive the other reforms. It's the reason why we need disclosure. It's the reason why we need public financing of elections. So we continue to have the debate because we have the amendment of a simple proposition, competing propositions. Do corporations have the same rights that we do, or are we a government of the people? And that conversation will help all the other statutory and regulatory reforms as well.
I'd like the three of you, if I could, to help me on a personal matter, but it's not a self-indulgent personal matter because I do think it goes to the heart of the argument we have about regulating corporations and their spending and campaign finance spending generally. If you are like me and write a newspaper column and argue for various forms of campaign finance reform and regulation, the argument you get back from the other side is, well, you write this column for a corporation. Your free speech rights as a columnist are untrammeled. why are you preventing Corporation Z out there from saying what they want to say in a political ad? What is the distinction between what I might do, what Fox or MSNBC or CNN might do, or the New York Times does? Can one of you brilliant legal scholars sort of define this difference? Because I do think that, having argued this for many years, I do think that's the argument that doesn't necessarily that's the argument that probably has the most bite with people when you are arguing about these matters. So who would go ahead?
Fools wade in where angels fear to tread. So here's my take on that. First, it's a question nobody asked for the first 200 years of American history. Until 1978, there wasn't any question that we could tell the difference between a corporate regulation and a speech regulation. We could tell the difference between freedom of press and the need for we the people to decide what's an appropriate corporate regulation. I think we can still tell that today if we are careful about how we think about these things. I mean, the New York Times is a corporation. That's what you'll hear if you support the amendment. Oh, the New York Times is a corporation. Well, how can you be against the freedom of the press? Which it is true the New York Times is a corporation. It is also true the New York Times Corporation, a publicly listed corporation, has to comply with SEC regulations and all sorts of other corporate regulations. And we know the difference between that and a column writer. And so we know that the First Amendment talks about freedom of speech and freedom of press. We know that the human beings who are writing stories and the human beings who are editing stories and publishing stories have full freedom of speech rights. So I'm not being flip about how easy all of these questions are. I think they're, in many instances, especially as you get into complicated areas of what is press today with the internet and what is speech, it sometimes gets difficult. But the way out of that difficulty isn't to, in my view, say, well, corporations are just like people and we can't possibly sort out the difference between speech restrictions and corporate regulations, so let's pretend they're the same when they're not.
I think that the Supreme Court, has been going on three metaphors, and I think, my answer to each of the metaphors is not that they're entirely wrong, but that they require a lot more thought than the Supreme Court in its smugness is willing to put towards it. And I think that those three metaphors are that money is speech, corporations are people, and elections are a marketplace. And to the first of those, I would say that, money is sometimes speech, sometimes it's not. Like I would say, having worked in grassroots fundraising, that if I get a $2 check from a little old lady who just really wants to support her candidate, then that feels kind of speechy to me. But if I'm getting a, $5 million hidden corporate contribution to the Chamber of Commerce trying to, take out some regulator on a particular committee, that feels a lot more like influence peddling to me. I would say, with respect to corporations or people, like I think that Google should absolutely have the right to put a black banner on its website to protest SOPA. I think that Twitter should be able to do the same. But at the same time, that's very different from the sort of influence peddling that we're trying to combat. And I think that, in terms of elections, are elections a marketplace that should be dominated by the, highest bidder according to the kind of social Darwinist principles of free enterprise? Or are they something more like a national dialogue, a national decision-making process more akin to a town hall? I think that all of those questions are quite difficult and require a lot of nuance, but the problem is that the Supreme Court has gone all the way to one side on all three of them.
I'm grateful for that, and one last thing before I open it up to the audience. It does seem to me that one of the most pernicious things that's happened to our political conversation over the last 30 to 40 years is the invasion of market metaphors in every area of human life. And the suggestion, and it's kind of the tyranny of a certain style of economics, where every human relationship becomes a market relationship. And just when you think about that sentence, that's pretty scary if you care about things like, say, the family, or a lot of other human relationships where we would not want to think of them in the same terms as we think of the economic market. Could any of you talk a bit more about that? As how does one combat this notion that the market is always the appropriate metaphor for all human interactions, because it clearly is not. It's not what our Republican, small r, founders believed.
Well, I mean, there are, one thing that we often, that we have been working on is this idea, in other countries, elections are not thought of as a bidding war. They're thought of as a time for national conversation. There was a bounded election period. Within those election periods, it's like, okay, we're going to have something that looks a lot more like a debate. Something that looks a lot more like, okay, let's have everyone have their say, and then let's have a deliberative process, and let's let the voters decide. It doesn't become whoever can spend the most gets to push everyone else off of the podium. And I think that particular problem I would trace not just back to Bellotti, but I would trace it to Buckley versus Vallejo, which makes the original kind of sin of the money is speech equation. And it did so in a particularly pernicious way.
Yeah, I agree with that. I think it's also, in some ways, behind my reference to the Lochner and the Gilded Age and the Progressive Era. We do have a debate in this country, have had a debate in this country about the role of the market versus regulatory. That's a perfectly fine debate, healthy debate. What the problem is when one side of that debate gets to constitutionalize their point of view. And then that's sort of the end game. And that's what's happening now, where the market metaphors that were debatable even in the policy sphere are now imported into how we think about our Constitution and our Bill of Rights, where they have no place whatsoever. And we are getting the same kind of, one side of a policy debate has pulled off a constitutional trump card where it really doesn't belong. And that's what happened with Lochner. It's why the Supreme Court was striking down child labor laws and minimum, a maximum hour wage laws, and work laws, things like that, because of this notion of freedom of contract, as if the one point of view, which is corporations can employ people until they drop and then get other people. Had a debate with the folks who thought we ought to have some balance with big industrial corporations, and they got, in effect, to constitutionalize a policy that was, dubious in the policy sphere, but very dangerous in the Constitution itself.
I was just going to say, they believe in this marketplace concept except for when they don't. So and I think it's up to us to point out how disingenuous that is. So for example, they may believe it when we're talking about campaign finance, but they certainly don't believe it when we talk about social issues like abortion or gay marriage. And that's when suddenly all of those kind of market ideas fall by the wayside, because then they feel perfectly fine telling everybody what to do, and the marketplace could regulate those things just as well. And so I think it's up to us to point out those inconsistencies and demand answers and explanations from candidates about how they deal with those.
I should, this is where disclosure sort of elides into self-promotion. I have a book that's coming out later this year, and one of the things I argue, and this is why I'm sympathetic to a lot of what you're saying, Jeff, is that our conservative friends have taken, it's one of the arguments in the book, have taken an exceptional period, which is the Gilded Age, and acted as if a 35-year window is the entire history of our country going back to the founders. And in fact, it seems to me that the Gilded Age jurisprudence is exceptional, not the rule. Gilded Age politics is exceptional, not the rule, and that if you really care about what America is and stands for and think hard about who we are, that has less to do with who we are than the broader 235-year trajectory of our history. So I do think that it's so important to put Citizens United in the context of all of those decisions back in that period, Justice Stephen Field and folks like that. Because it was a very different period against which we revolted, both starting with the populists and then with the progressives.
And the original campaign finance regulations dates back to that era. I mean, if you think about the Gilded Age, you could buy not just a candidate, you could buy a voter. I mean, you could buy votes. It was perfectly fine. And I think it was the institution of the secret ballot, the idea that it became illegal to pay people for their vote, or even to pay people to register to vote, that defined an idea that, no, this is not what Americans think about elections. Americans do not think of elections as an auction block, but trying to articulate what we do think of elections as has, I think, been a harder blank to fill in.
This reminds me of a wonderful story that if somebody is watching this, they can tell me if it's true, although I've always been told it's true, and I hate it if it weren't true. There's a story of a machine in Albany was very effective, and there was an indictment of a whole series of people for buying votes at $5 a piece. And then there was one guy who was indicted for buying votes for $3 a piece. The only guy who got convicted because the machines control the jury was the guy who bought them for $3 a piece because he had embezzled $2 of the machine's money. Let's open it up for questions. Let me start with my friend Garrett, if I could be permitted.
Hi, I'm Garrett Epps, and I just want to...
Why don't you give your title and your new book?
Oh, yes, forthcoming book called Wrong and Dangerous, 10 Right-Wing Myths About the Constitution, some of which are involved in this. But I want to sound a couple of cautionary notes. First, about the Blumen versus FEC case. I don't think it would be very wise to read much about the court's attitude toward these issues into that. It's a summary affirmance, which a lot of us interpret as the Roberts Court saying, we're not getting into this issue in a presidential election year. We don't want to, they know that they've created a lot of controversy. I think the issue of foreign contributions and contributions generally is coming down the road, and I don't see much disposition in this court to back off. I also want to quickly say, I don't think it's an easy case to tell how we regulate corporate speech and yet somehow don't regulate media. I don't think that's an easy question at all. And I think if you look back, in fact, at Justice Rehnquist's dissent in Bellotti, which you referenced, the real root of that was his rearguard action against New York Times versus Sullivan. Because New York Times versus Sullivan, which is the bedrock of press freedom in this country, was opposed on the grounds that this was just an advertisement in a commercial publication. This is just commercial speech. How can you possibly say the First Amendment prevents a state defamation judgment against it? And that's a cautionary note. It's not to say we shouldn't move forward really strongly on this issue, but let's not fool ourselves that it's going to be easy to do this without doing damage to genuine questions of media freedom that we really care about.
A challenge for somebody to take up.
I'll take it. Mainly just to correct any impression that I would suggest any of this is easy. I think your point is very well taken. I think most cases that end up in the Supreme Court are there because they're very difficult. But my point is, nobody's talking about changing a word in the Constitution in terms of freedom of press, freedom of speech, anything else. There will be lots of hard cases that will come to the court after the amendment is ratified, and some will involve media corporations. And I think New York Times versus Sullivan obviously had a context of Alabama at the time and the struggle for equality at the time. I think we have a context now of elections and other sort of competing constitutional values that the court is acting as if those are easy. When they, as Monica said, that I think there's perhaps a lot more nuance that the court could bring to these cases, and hopefully I would see a successful amendment campaign helping to bring back that sort of nuance rather than sort of the overriding metaphor of sort of a corporate person.
Anyone else want to take that? Or let me go to that over there. Yeah, right against the wall.
Thank you. I'm William Klein. I'm the campaign manager for Murray Hill Incorporated for Congress, the first corporation to run for Congress, and I'm joined by our designated human here. When the Citizens United case came down, we decided that the best way to take this argument to the American people was to put it in a context that most people could relate to, which was the daily to and fro of a political campaign. We went around the country, did lots of media. We're still involved in the presidential campaign. But we found, that some people were really outraged and appalled by what we were doing, and some people seemed to think it was satire. We have no control over that interpretation. But a lot of people had no problem with our basic tenet that, that It's often said that we have the best Congress that money can buy, but sadly this ideal remains unrealized, and it would take direct election of corporations to really make our process more honest and above board. So I guess my question is I think that part of that is because the whole system of politics, the whole concept of our political system is so discredited and so removed from most people's lives that this whole issue of unlimited spending and the true position of our corporate overlords in our daily lives is accepted. You'd be surprised at how many people, even in so-called liberal media, we never ever suggested that we were anything less than 100% serious in what we were doing, which of course we are. But the question is, people don't really buy into the fact that they have a stake in politics necessarily, and that this really matters, that they are in fact used to being commodified. So what do we do to make people feel that this is really important to them?
Thank you. That was both entertaining and informative, and I hope you take your case to court. If we could ask people from here forward to sort of contain their question. Anybody have a response to that?
I think, one thing that's very interesting to look at in terms of what makes people feel a stake in their campaign is, or in their candidates, is public financing. Because you have a lot of these public financing programs where a $5 contribution can make a major difference in terms of the candidate reaching a qualification threshold, or being able to run a viable campaign. In New York City, we have, I think, the longest running public financing program in the country, which is done with massive candidate participation, massive popular participation, and it really does make a difference, I think, both in terms of the candidate and in terms of the electorate.
One thing I'd like to add to that is one of the things that Crew believes you can do about that is you need to make the case to the Americans that their interests are being sold off. So what is the money, what's it buying exactly? So they're getting legislation that benefits banks at the expense of consumer protection. And so I think you really need to constantly show the links between the contributions and probably the super PAC money and what actually happens next. What do we see? What's the action we see Congress taking? And one of the things I think people will start to see because of the super PAC money is because of the fear of the amount of money that will be spent against people, will they change their positions? Will the threat of the money being spent be enough alone for people to start, members of Congress to start changing their votes and vote in a way to try and ward off super PAC expenditures?
In the interest of worker self-management, could you pick a few folks for me that are convenient to walk to, and then...
Hi, my name's Les Myers. I teach business ethics and corporate responsibility at Georgetown. Hi, EJ.
How are you?
And thanks for your great comment regarding commodification of persons and relationships, because I think that's right on. The thing that struck me, and I've thought about it a number of years, is that's a peculiarly Marxian way of approaching things, the economic determinism that should color all of our relationships. And it's really striking how conservatives are behaving almost like Marxists when they talk that way. I really liked Melanie's response in terms of differentiating types of issues to show those distinctions. And I think even within this small issue of the behavior of corporations in society, one way would be to look back at Milton Friedman's great argument from 1970, with which I disagree, but it was a powerful argument that the only purpose for a corporation in society was to be profitable. And he's arguing out of Hayek's vision that there's economic freedom and political freedom. And the punchline of Milton Friedman's argument in 1970 is, we don't want corporations to try to be socially responsible because it would represent government taking over corporations. And that was in 1970, and as I tell my students at Georgetown, it's 2012 now. Are we really worried about government taking over corporations, or is it possibly something else?
Hang on to that thought. Why don't you pick a couple of more people out there, please?
My name is Stephen Shore. Two brief questions. The word corruption has been used, but doesn't that presume a state of innocence to begin with? And my second question is...
That's a theological question.
Okay. Isn't it inevitable, given the makeup of the Roberts Court, that foreign corporations will be allowed to contribute to the American political process? Certainly, American corporations have not been shy about interfering in foreign elections.
I wanted to respond to the first point because the framing of everything in terms of corruption is a relic of the conservative majority of the court over the last 30 years, who have said that the only justification that justifies government regulation of political campaigns is this corruption interest, which, as you say, presupposes a baseline of what is not corruption. Chief Justice Roberts has further defined corruption only as quid pro quo corruption. But, you know, if you look at the Constitution and the way in which the Constitution has defined authority over elections, we, the people, have always had the opportunity to define what is going to be the kind of government that regulates us and what are the processes by which we can put in place that kind of government. We have been able to set up any number of different political systems in the states, from single-member districts, multi-member districts. We've been able to define as a political community how we want to be represented. And I feel like the Supreme Court's insistence that the only regulation of political campaigns can be in terms of this incredibly narrow definition of quid pro quo corruption is a real encroachment on the prerogatives of we the people to say who we are and how we want to be governed.
Any of those?
Yeah, thanks. I want to pick up on the comment about corporations and the sort of purpose of them, because I think it sort of goes back to your point, E.J., about we have 235 years of history, not just a narrow window. And corporations in America have always been treated with suspicion at times, and but some vigilance at times. I mean, the early corporations, as many of you know, were limited in time to 20 years. They were for a public purpose, get a bridge built across the Charles River and then shut down. They were considered extraordinary vehicles of government privilege to accomplish a public good. And now we have sort of locked into the corporation as it existed in the Gilded Age, as if that is something that came down from on high, rather than a tool that needs some revamping. And so I think, part of this sort of, if we achieve it, this renewal of not only our elections, our democracy, but our, the lobbying system that even Jack Abramoff calls bribery now in his new book, but the renewal of this corporate tool. There are things like B corporations, for-benefit corporations. 7 states now have enacted laws essentially overruling the idea that it has to be for the shareholder profit only, that for-benefit corporations are not nonprofits, they're not for the shareholders only, they allow the managers of a corporation to take into account community standards, environment, labor, things like that, without getting sued by a shareholder derivative suit. So there's lots of these tools that we can look at if we can begin to imagine that we are not locked into one narrow particular way of thinking, both about our democracy and about our economy.
I just want to take what I called your theological question, because I don't think the implication here is that there was some pure political system and now it's corrupted. In fact, one of the things that's so powerful in Justice Stevens' dissent is his argument that from the very beginning, the founders were obsessed with corruption, and they had a very realistic, let us say, view of human nature. And his argument is that the small r Republican view here is that the people and the legislature have a right to legislate in order to control certain, unfortunately, natural tendencies that people might have. Is that a fair rendition on my part? Because I just like somebody to deal with that, because I think it's an important question.
Justice Stevens there is, I think, referring back to Zephyr Teachout's article, which he cites on the anti-corruption principle, in which he goes back to a whole lot of founding era documents and says that, the ability to defend against corruption should be considered a structural principle of the Constitution, similar to federalism, similar to checks and balances. I mean, this is one of the constitutive concepts of our Constitution. But I think that there's also an important, why should the courts be saying how we should be governed? I mean, for a federalist court or for a court that that pretends to be federalist is particularly interesting because we've always thought of the states as laboratories of democracy. I mean, you can see Montana doing this now, saying this is how we want to be governed. If we want to have appointed representatives, we'll do that. If we want to have elected representatives, we'll do that. And if we say we don't want our representatives to be bought and sold by corporate interests, why can't we do that too?
I'd love to have an event with Zephyr Teachout, actually, because I think that's a fascinating argument she makes. Sir, pick out some folks in the audience here.
Hi, Doug Kendall from Constitutional Accountability Center. Jeff, I really appreciate the shout out to the issue brief, which is on the back table if anybody wants it.
Closer to your mouth, just so everybody hears you.
Yes, and I'll stand up if you want me to. The issue brief is on the parallels between the situation we are in right now and the situation that the progressives and populists faced in the turn of the 20th century to overturn a 5-4 pro-corporate ruling in Pollock versus Farmers Loan. And it really has some interesting and lovely little stories for progressives now trying to overturn Citizens United. One of the great things, and it shows how the amendment strategy and a reform strategy play together, is that a lot of conservative pro-corporate Republicans backed the amendment strategy because they thought it was impossible. And so that was the way they could prevent anything from happening, and it kind of turned around and bit them, as the chamber's lobbying strategy is said to do. The question I have, so the parallels are really interesting. The difference right now is, I think, the polarization in our political climate and the kind of the knee-jerk opposition to any of this stuff among Republicans. And that was different back then. You had like the initial outrage against the Pollock opinion was from the populists and the Democratic Party led by William Jennings Bryan. Then it was picked up by Theodore Roosevelt, even backed by the very pro-corporate conservative William Howard Taft. And that's what, I mean, we have, the thing that we have right now in opposition to Citizens United is this polling, which shows how unpopular the ruling is across the political spectrum. We don't have any of the politics, you know, the strange bedfellows in politics, other than John McCain, who's kind of backed off on it at this point. How do you?
Although he still does criticize Citizens United and the FEC. Yeah.
Just have anyone on the panel have any thoughts about how you scramble the politics on this issue, how you use the polling to make this a little more interesting political debate going forward?
I do think you can work with the Tea Party, but that's because it's hard to know who the Tea Party is and who you work with. But Tea Party members overwhelmingly are concerned about corruption. They do believe that their money is playing much too much of an influence in politics. So I think no one has yet worked out how to partner with people with that view to bring them into the Citizens United discussion. But I think that considering the views that they have and that the polling shows that they believe this so deeply, that I think that's really where the next step is.
I also think a lot of work that can be done in the states, because I think that the National Congress is, of course, incredibly polarized. Some of that polarization is going down to the states, but you do see coalitions building in the states around these issues that are not as, Mitch McConnell orthodoxy enforced as the current Congress is. And so there are ways to move beyond that deadlock and to start local and to try to build something national that way.
I agree. I think the test will be whether we begin to see fracturing of some old line alignments in both the Republican and the Democratic Party, which I think did happen in the progressive era. We had a progressive party, if you will, and a third party emerging in the states at first, and it's sort of fractured some of the old lineups. And I think we have what I would call a corporatist viewpoint that is convenient in the Democratic Party to work with at times and convenient in the Republican Party. Both parties have significant and growing wings that reject that approach. And I think one interesting lineup was Bernie Sanders and Ron Paul working together on Audit the Fed. and you know, who would have thunk? So I think we will. This is so powerful in the country, including among Republicans. We'll see what happens in 2012, but I think, you know, those politicians of either party who run on a reform agenda will do well. Although I suppose Buddy Roemer is Exhibit A, that isn't necessarily working right now is in the Republican primary.
I think that is simply an unrealistic view of how the forces are arrayed right now. And that what you have, and the Tea Party, I think the problem there is that a lot of Tea Party people are profoundly libertarian, which is a view they have every right to hold and advance. But it tends to be a view that opposes the kind of regulation that everybody in this panel supports vis-a-vis campaign finance reform, and that when you look at voting, you do not at the moment have that fracturing that you're talking about at all. You have had fairly a surprisingly uniform view on the Republican side, which is a very recent development. I mean, there used to be, as recently as 10 years ago, a very substantial number of Republicans who were McCain-like reformers. At the moment, it appears that you have a decision based either on interest or principle, that is to say, a Republican Party that emphasizes property rights and a certain view of individualism more than it used to. And I'd just like you to address that, because I think it's easy to toss out, oh, this'll change and be bipartisan. I don't see that on the horizon immediately, and I'd like to know the forces you see out there that might make it happen, because Lord knows we'd all like it to be less purely partisan than it is now.
Yeah, and to be clear, I'm not talking about a bipartisan strategy or a tactic to get something through Congress right now. What I'm talking about is what some call transpartisan. It's not postpartisan. It's that we have partisanship, but they agree on one particular thing. And I'm most focused on the constitutional amendment when I say this. And I am not convinced that we will talk libertarians into supporting government-funded elections. But there is a significant piece of the libertarian movement that is talking about crony capitalism. There's a significant piece of the right wing that believes that the health care bill that passed was a corporate-driven bill that provided massive subsidies to pharmaceutical companies, mandated no negotiations with the government for pharmaceutical companies at taxpayer expense, and mandated customers for private health insurers without a public option. So those kind of issue-based focuses, where you're looking at what is our government delivering now, and what do people want. I think we'll see some alliances now. If I was doing just pure what does it look like right now, I never would have tried to start an amendment campaign, because sometimes democracy is the bet on the unrealistic and seeing what happens. So.
Could I bring in this lady right here as for the last question? Oops, there's our mic guy, and then you could come back in. I'd like her to, yep, he's coming around to you. And then I'd like you to come in and also just offer some closing remarks at the same time, please.
Hi, I'm Kristen Cabral. I'm from Virginia, Battleground, Virginia. And I was wondering, how can we broaden the paradigm that corporations are creatures of the state? They're public, right? And publicly traded, a lot of them. And I come from it from two angles. One, they're incorporated in states, particularly Joe Biden's Delaware, where his son is a state attorney general. And two, the Supreme Court seems, if we're just going to look at this in blatant politics, very pro-corporate and quite, almost anti-government, so much so that just moments ago they ruled unanimously that a search warrant is needed when police use the GPS devices to track suspects, 9-zip, okay, against the government. And we know they love corporations. So if we can turn corporations into public entities, because they hate public entities like the government, maybe we'll win a little more. I don't know. Just trying to get out of the private-public duality that we're dealing with now and kind of turn corporations into that public sphere.
So why don't you make the earlier point you wanted to make, and thank you very much.
Well, that actually ties very nicely into the point I wanted to make, because I don't think we should be thinking of this purely in terms of lawmaking and public regulation. I mean, I think that we need to make the point that corporations are public entities, and to be able to, we are not only voters, we are shareholders, we are pension holders, we are people who have a say in these kinds of things. And many corporations, I think, have been relatively amenable to the idea that they don't want to be in a situation where politicians are begging them for $1 million in handouts every election cycle. They don't want to have to be bribing politicians all the time. That's not the sort of business they want to run. And so there are a number of, of Fortune 500 corporations who are already starting to improve their disclosure practices. I think that the big black box in that is still the Chamber of Commerce, but there are in fact big corporations who are divesting themselves of the Chamber of Commerce, who are saying, look, the kind of, extremely partisan bidding war that you want to get us involved in is simply not how we want to do business. And I think that thinking of that as another point of leverage, in addition to simply political points of leverage, is a point that really shouldn't be lost.
I quite agree. I think it's a very good question, a very good point. And I sometimes joke with my libertarian friends that no self-respecting libertarian would go down to the Secretary of State's office and beg for limited liability and all the other government privileges that come with using a corporation. But we, Free Speech for People, not only is an amendment campaign, but we are about corporate accountability. We've asked the Delaware Attorney General to revoke the corporate charter of Massey Energy, which killed 29 miners in an explosion that the two independent reports and the United Mine Workers called industrial homicide. Because they had 65,000 violations of law. They've got criminal convictions. They essentially match the criteria for states revoking corporate charters, which almost every state in the country still has on its books a charter revocation law for when corporations are misused. And it has been a law that has been overlooked for too long, and it is almost the epitome of these things are public privileges. They're not simply private arrangements, and we can use these tools to begin taking them back as part of taking back that public accountability.
I think that it's really up to all of us to be vigilant and demand change. We can't sit back and just say that it's awful. We have to sit there and think about new and interesting ways that we can work to make change.
Perfect. I want to say that I think I've always been taken by an argument made by a philosopher, Michael Walzer, in a book called Spheres of Justice, and that money has its legitimate realm in which it operates. The market is a legitimate sphere, but there's also love, there's life, there's self-government, there's justice in the courts, and that we need to protect some spheres against the other spheres, and that those who advocate for reform in this area are asserting that we ought to be equal citizens at election time, and that there ought to be things that aren't for sale. And I think that is at the heart of what we are talking about. I want to thank this very, very distinguished panel and all of you for participating. Thank you.
I'm Andrew Blotkin, the Director of Legal Progress here, and I just wanted to thank EJ and all of our panelists for joining us today. This obviously is an issue that sort of transcends policy issues, constituencies, people across the income spectrum, across the political spectrum. It's something that we will be obviously working on together in the months and years ahead. So thank you all very much. Thank you.